In this video, we're going to continue discussing the circumstances in which constructive trusts arise, and specifically we're going to be looking at land and secret trusts. So another time when a constructive trust can arise is when we're dealing with land. A contract to sell land is specifically enforceable. So a contract for the sale of land is specifically enforceable where the remedy of damages would be inadequate. Contracts relating to personalty are rarely specifically enforceable as the property may be purchased elsewhere. If this is not so, as in the case of shares in a private company, then the contract will be specifically enforceable, as we'll see in the case of Alltrade and IRC. In the present context, however, we are mainly concerned with contracts relating to land. The availability of specific performance means that in equity, the purchaser is regarded as already the owner. Thus, it has many times been said by high authority that a vendor of land on the conclusion of the contract of sale becomes a trustee of the land for the purchaser. So the vendor on conclusion of sale holds it on a constructive trust for the purchaser. So until all the forms have been filed and everything has been signed and finalised, there is a moment where the property has not actually changed hands, both physically and legally. The rationale behind the operation of this principle is as follows. So once the contract is formally created, the contracting parties acquire rights of specific performance to force the other party to perform its part of the bargain, on the basis that each party has a right in equity to specific performance, and on the basis further that the contract is one to transfer title and property, it is said that the party so entitled acquires a right to the entire equitable interest in that property. Therefore, once such a binding contract has been formed for the transfer of property, it is said that the equitable interest in that property passes to the buyer automatically on the creation of the contract. The automatic vesting of the equitable interest is said to arise due to the equitable principle that equity looks upon as done that which ought to have been done. Therefore, equity considers that because the contract requires the transfer of title, title must be deemed to have taken place automatically. So, if the transfer ought to have been specifically enforced, equity will recognise the transferor as holding the property on constructive trust for the transferee until the transfer is actually enforced. The constructive trust arises from this equitable principle on the basis that it would be unconscionable for one of the contracting parties to refute its specifically enforceable obligation to transfer title to the other party. The vendor must take reasonable care of property until completion, so in the interim, the constructive trustee has this responsibility. He must take reasonable care to preserve the property pending completion. Any changes in the nature of the property between contract and completion, for example by fire or flooding, if they occur without the fault of the vendor, are at the purchaser's risk. Okay. The vendor has responsibility because we have a split of interests, legal and equitable. So the seller has the legal interest and the buyer has the equitable interest during this interim stage. So the transfer of the equitable interest takes effect by means of a constructive trust. This is not the same as trustee and beneficiary, since each have their own interests, but enforceable like duties of a contract. So this is different to a trustee and beneficiary, but it's the same sort of idea. There is a responsibility. In other words, it is clear at least that this is not an ordinary trusteeship. And Cotton said in Rayner and Preston from 1881 that the vendor was a trustee only in a qualified sense. Similarly, the vendor is entitled to keep for himself the rents and profits of the land, or dividends in the case of shares, until the date of the completion of the sale. So once the date for completion has arrived and the price is paid in full, the vendor must immediately convey. Does not pass to sub-purchaser. So a further question is whether the vendor becomes trustee for a sub-purchaser if the purchaser of the land has entered into a subsequent contract to sell to a sub-purchaser. In such a case, the sub-purchaser, by virtue of his contract with the purchaser, is entitled to specific performance and is treated as the owner in equity. So in the case of Barclay from 1977, the vendor with the concurrence of the purchaser, had allegedly allowed certain fixtures to be taken away. The sub-purchaser claimed that the vendor was in breach of the trustee's duty to take proper care of the property. A majority of the Court of Appeal considered that no fiduciary duty was owed to the sub-purchaser. It was not that the vendor was a trustee and therefore had fiduciary duties, rather that the vendor owed duties to the purchaser and was labelled a trustee. A sub-purchaser's right is to have the purchaser enforce the contract against the vendor. And as I've already mentioned a couple of times, this relationship is one giving rise to contractual duties, not fiduciary duties. Okay? And contracts for the sale of personal property are not generally enforceable unless unique, as seen in the case of Altred and IRC from 1960. So in this case, a mother and son wished to exchange title in valuable shareholdings so that the mother could consolidate a larger shareholding in one company. Now, both sets of shares were held on trust for the mother and son, respectively. To have effected the documentary transfer of the shares necessary to transfer legal title would have attracted liability to stamp duty. The parties' intention was to transfer their legal title without the need for the documentary transfers, and further, by avoiding the need for signed writing under Section 53 of the Law of Property Act 1925, necessary to dispose of the equitable interests in the share of one another. Therefore, the mother and son created a contract between them by which they agreed to exchange their respective shareholdings. And it was held that such a specifically enforceable contract was sufficient to constitute an automatic transfer of their shareholdings. That this shareholding has been held to effect an automatic transfer of the equitable interest means that the stamp duty levied on the document of transfer of the legal title is levied on a nil amount on the basis that all of the value in the shareholdings move with the equitable interest, and in turn the equitable interest moves as soon as there is a specifically enforceable contract in place between the parties. Until the document transfers legal title to the intended recipient, the legal owner is constituted as a constructive trustee of the equitable interest in that property. Okay, so that is some of the situations in which we can see how land gives rise to a constructive trust. But we've also got secret trusts as number 5 in our list of different things that give rise to constructive trusts. So secret trusts take effect on the testator's death and do not comply with the requirements of the Wills Act. So a secret trust arises when a testator wishes to benefit some person who cannot be named in the will. Therefore, the testator will ask a trusted individual to agree to an agreement whereby that individual receives a gift under the will ostensibly for their own benefit, but which is in fact to be held on trust by that person for a third person who cannot be named in the will. So these secret trusts do not comply with the Wills Act. The testator normally leaves the properties to someone, so prima facie it is an outright gift. So if the testator leaves the property to someone that is going to, if the testator leaves property to someone else, on the face of it, that is going to look like an outright gift. But the donee has agreed to take on certain trusts. So that's what we mean by a fully secret trust. So prior to their death, the donee of the supposed gift agrees to take that property on trust for another person, some third party, and this is what we mean by a fully secret trust. So we create this constructive trust because they agree to hold that property for the benefit of someone else. If they later decide to just keep the property, it would be unconscionable. In other words, they'd be benefiting from an agreed fiduciary relationship which they are not allowed to do. So a constructive trust is created to give the property to the correct individual. Secret trusts are traditionally justified on the basis of the doctrine of fraud. So the original purpose of the doctrine of secret trusts in the early case law was to prevent statute or common law being used as an instrument for fraud. But the modern doctrine is that the secret trusts arise independently of the will. So oral evidence of the agreement between the testator and trustee are generally satisfactory to give rise to a secret trust. We've also got a half-secret trust. So a half-secret trust is where property is left on trust in the will, but without specifying the terms of the trust. So sometimes the will say that the property is held on trust, but fails to say for some reason what is supposed to happen when, the property, what will happen with that property. So this is really what we mean by a half-secret trust. Now, fully secret trusts are frequently identified as constructive trusts, whereas half-secret trusts are often considered to be species of express trust because they are disclosed on the face of the will. However, there is some debate between academics on this point. The argument is that all secret trusts ought to be considered constructive trusts, affected to provide an exception to the Wills Act 1837, and thus prevent a legatee under a will from asserting an unconscionable beneficial title to the property. A secret trust is not properly constituted by the settlor by the substance of which was communicated to persons who are named as legatees under the settlor's will. As such, the enforcement of the settlor's promise could not be an express trust because the settlor retains the right to change her will, something which would not be permitted if an express trust had been created over that property. So I think that the only viable trust law analysis is therefore that this secret trust must form a constructive trust. And so finally, why create a secret trust? Why do people even bother making a secret trust? Now, usually it's to keep the identity of the beneficiary secret. So usually secret trusts are used where someone has had an extramarital child and they don't want their spouse to know. In other words, they want to provide for this child but don't want their wife to leave them. So frequently secret trusts are made to benefit a mistress or illegitimate child after the testator's death in a way that does not require them to be disclosed in the will. Another circumstance is where the testator is undecided about dispositions. So if a testator isn't too sure about the details as to who should benefit, then secret trusts may be useful. And finally, subject to some conditions, secret trusts are enforceable despite not conforming with the Wills Act. And this is something that we've already talked about. Okay, so that is the end of the next part. In the following video, we're going to be talking about another circumstance in which constructive trust can arise, and that's in cases of fraud. We've got a couple more videos probably on this, and then we're going to move on. But if you have any questions at all about this video, then please leave any comments and questions below. And if you enjoyed the video, make sure you give a thumbs up and subscribe to my channel. Thank you very much for watching.